If you were arrested for domestic violence and you were given a court date, but you haven't been to it yet, there is still a chance that the prosecution will drop the case before court. And in this video, I'm going to be explaining 7 steps to increase the likelihood that will happen. So by the end of the video, you will have a much better idea of what you can do now and what an attorney can do for you to try to increase the chances that you can get this whole thing dropped and move on with your life. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything you need to know to represent yourself at your restraining order hearing and win. I'm also the creator of a course called Defeat the DVRO, in which I teach you everything you need to know to represent yourself at your restraining order hearing and win. If in addition to being arrested, you were also served with a restraining order, make sure you get your free first class in the course via the link down below. Okay, so let's jump right in. 7 steps to get your case dismissed before court. As you may or may not know, after you get arrested, the police write up their report and they give it to the prosecution. So the prosecution, also known as DAs, district attorneys, state's attorney, their office still has to look at the police report and anything else in their file and decide, is this the case that we want to prosecute? So what this means is that even though the police have arrested you, there are no charges actually filed. And so before your first court date, when the DA's office is making that decision, are they going to file against you or not? You do have the opportunity to have an attorney contact the DA's office and potentially get them to drop the case. But in order to maximize the chances of that happening, you have to be proactive and you have to do this very quickly. If you wait to hire an attorney until the day before court or even the week before court, it may be too late. The DA's office will have already reviewed the police report, which we know is probably not going to say anything good about you if you were arrested. So you do need to act quickly and be proactive. Now, step number 1 here is you need to enroll in domestic violence classes. Now, you can do this online. I'll put a link to the one that I recommend to my clients in the description box, but there are multiple domestic violence classes online. You need to enroll in that and get some hours in. Now, I know that this suggestion may sound stupid or crazy because it sounds like you are admitting to domestic violence. You may be thinking, but I'm innocent of this charge. Why would I take classes, right? If I take classes, it sounds like I'm an abuser and I'm learning how to not be one. And that is normal, that is rational and logical. But from the district attorney's perspective, the more that you can reassure them, the more that you can show them, hey, if you had any concerns about me or about this situation, look, I already took these classes. District attorneys, judges, our entire criminal justice system in the state of California loves to send people to classes. It provides them some reassurance that if there was a problem, they maybe don't know 100% what happened, but if there was a problem, you're getting help for it. And it also shows that you are someone who takes this very seriously. You want to show them, look, you are not going to see me here again. Maybe this was a mistake, maybe it was self-defense, whatever it was, you are not going to end up being one of those repeated arrestees. That is what they want to see. And this applies even if you do have some criminal history. They want to see that you are taking this very seriously. So enroll in online classes. The one that I recommend, I typically tell people just take 8 hours because that strikes the balance between I don't want you to take a month to do this. I want you to do it very quickly. I tell my clients within a week usually of hiring me, and hopefully we have at least a month before your court date. But it's enough to show that you are serious about this. Number 2, enroll in individual therapy if you don't have a therapist already. Now again, that provides some reassurance to the DA that you do have a support system, you do have someone who you're talking to, someone who is responsible for you. It can take a while when you're trying to go through insurance sometimes if you don't have this already set up and you're trying to make an appointment, but you can literally just do this online. The DAs will accept it the same as if you go in person. Just make sure you go somewhere that you can get proof. The one that I recommend to my clients, again, that's in the description box here. It is separate from the domestic violence classes. I recommend them because it is very easy to get proof very quickly that you are in this individual therapy. Number 3, if the alleged victim is on your side, get into couples counseling. The alleged victim has no ability to drop the charges. It's not like a civil lawsuit where one person is suing another. It's not like family law court where it's one person versus another. It is the government against you. However, one thing that can really help is if you can convey to the state that the two of you are working through this, that you do have a professional looking at the relationship, making sure that everything is okay, and that basically this was one really bad night, one really bad day where for whatever reason the police did get involved, but nothing like that is ever going to happen again. And couples counseling is really helpful for that. And this can be done online. There are plenty of places online that offer this. Again, you want to make sure you get proof and that you can start quickly. So if you don't already have a place in mind where you want to get this done, and some people do go through their church or whatever for free, as long as you can get proof and start quickly, that's fine. But you can do this online, and there's a link for this one in the description box too, the one that I send to my clients, where they can enroll and get proof of enrollment immediately. Number 4, if you have any evidence, like evidence of your own injuries, if you were just acting in self-defense, for example, if there was a witness around, not a child, but if there was an adult witness around who can provide a statement that's helpful for you, start gathering that evidence. Now, you may not have any. This is only if you have some. If there is something that applies to your case that you think is going to be helpful, make sure that you gather that right away, give that to your attorney. If you have injuries, of course, take photos of those right away before they heal. Number 5, when you get an attorney, have that attorney write a letter, and they will know this anyway. You probably won't need to suggest it to them, but have them write a letter explaining all the good things about you, who you are as a person. So we want education, work. If you came here from another country and worked really hard to get here, then that would be an example of something we want to explain. The history between you and the alleged victim, if the two of you are married, if you have kids, we would want to include that in there. Just providing a picture to them that's not going to be in the police report of how you are a good person, a normal, productive member of society who deserves a second chance. Number 6, get character letters from your family and friends. A frequently asked question is, what exactly should these say? So the idea here, we can't have just a cookie cutter response. If I were to give you a template for a letter and everybody was to start using it, even if I just gave that to my clients and everyone started to use it, then it wouldn't be as effective. What we want here is for them to vouch for you as a peaceful, kind, hardworking person, how long they've known you, why they're vouching for you. If you do have family or friends who are members of law enforcement or have some sort of other title that they can provide in there, then that can be helpful too, because again, our audience is the DA, and that does carry some weight with them. How many to get? Obviously, this is something that it could take some time. If you had a year to gather character letters, you would have more of them, and they would be longer and stronger probably than if you just had a week or two. But sometimes you will ask people to write a character letter, they will procrastinate and not get it done. I would say about 3 to 5 good letters is fine. If you only have 2, it would be better to just go ahead with that than wait possibly weeks and maybe the DA makes their decision before your attorney can even contact the DA because you're waiting for this letter. And number 7, have an attorney contact the DA as soon as possible with all of this to describe the good things about you, to describe your side of the story, if there is any evidence to explain that. Take this opportunity before court when the DA's office has not made up their minds to prosecute you, to convince them to give you a second chance. And I hate to say it, but when the DA's office sees that you have an attorney, and I'm not talking about a public defender. If charges get filed against you, yeah, you'll get a public defender. But when the DA's office sees that you hired an attorney, that you are going to do everything that you can to fight this, you're not just going to accept the first offer or accept a conviction in the case that's going to ruin your life, they are much more likely to give you a second chance. Why? A big part of it is that when you have a private attorney, it is often going to take the DA's office a lot more resources to fight you and to convict you. You're not just going to take the first offer on the first court date. You are going to fight this thing. Your attorney is going to file whatever motions are necessary. They're going to have a lot more time to spend on the case than if you were to just use a public defender. And that means that the DA's office has to, if they want to prosecute you, they also have to spend more time on the case. They only have so many resources, and so that can tip the scales in your favor. I hope you found this video helpful. If you do need help with a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.